himself. Okay, next thing that we have is strict liability and absolute liability. All right, so usually what happens, what is thought, it is wrongful act or omission from one person plus damage caused to another person that gives some kind of a legal remedy. That means I had some rights, you violated my rights through an act or omission, and later on I have a remedy. That is what tort is. Now there are these two principles which are called the strict liability and absolute liability. These are called as principles of no fault liability. Like yesterday we discussed, under Motor Vehicles Act, even though it's not your fault, even though someone is busy speaking on the phone and they met with an accident, you will be held liable to pay compensation without having your fault, right? That means court will not look at guilty intention, court will not look at whether you were at fault or what. You will be made liable even without fault. That is called as no fault liability. Both of these concepts come under this only, no fault liability. All right, so there are two principles, strict liability and absolute liability. This is developed outside. It's like a foreign concept that we had incorporated, and this concept is developed in India. Absolute liability is developed in India. And the one that you see under Motor Vehicles Act, right, that is called as absolute liability. So if there is a question on Motor Vehicles Act, you can say that it's making the person absolutely liable even without having fault also. So these two principles are there. We'll quickly see what is it. Now, both these concepts were developed in two different cases. All right. Absolute liability is an Indian concept, so it was developed in an Indian case. And this one is a foreign concept that we have incorporated. So it is Rylands versus Fletcher. This is a case where this liability was developed. Okay, if you can just remember the names, Rylands versus Fletcher. Other one is MC Mehta versus Union of India. Simple name only, because inside there you will remember. So I'm saying if you can remember this. In this case, what happened is there were two neighbors. Rylands and Fletcher, they both were two neighbors. One person was having a mill, all right, where they will basically grind things, right, and give to customers. He was having a mill, and to run that mill, he would need electricity in a huge quantity, right? So he thought that why not I start producing electricity, or for that he would need water. So he thought that I will start storing water inside my premises only so that I can use it for my meal. All right, now to store water, he wanted to construct a reservoir so that he can store water there. All right, so he thought that I will construct a reservoir inside my premises only, and there I can easily store water for my meal, right? Whatever I would need, I will do that. For that, he hired some independent contractor. So what was the difference between independent contractor and a servant?
For a servant, his master will tell him to do something specifically. Sorry, and the master will tell him something and tell him how to do it, how to go about the steps and everything.
Yeah.
But an independent contractor, generally client will generally tell him what he needs, and the independent contractor does on his own.
Yeah, to an independent contractor, we just tell what is to be done, but to a servant, we also tell how it is to be done. So in this case, what happened? One of the neighbors was having a mill inside his property, and for that he needed water, and he thought that why not I store water inside my premises only. For that, he decided to construct a reservoir. While doing that, he hired some independent contractors and engineers who would look after that work. Now, while doing the work, right, he just gave that work to those independent contractors and engineers, and he was not going there looking after it or anything like that. They were basically independent contractors. While doing the construction, they saw that there were some old coal shafts there. Like it was basically like these kind of some holes will be there, which is unused basically. right? For mining coals or something, they had made it. It was unused. It was there. All right. These kind of some holes were there basically. All right. Some shafts were there, and independent contractors, what they did is they saw that there were these old coal shafts, but they just ignored it. They did not properly fill it, seal it, or something. They just slightly covered it, and on top of that, constructed the reservoir. And once the work was done, they just handed it over to the master. All right. So after that, the person who had constructed, right, he started storing water there. But because he had filled so much of water, right, it escaped from his premises and it entered the neighbor's premise. All right. So from his land, water escaped and it entered the other person's premises, and it caused heavy loss to the other person because water was stored in such a huge quantity, everything escaped from his premises. So in this case, the person filed a case that I should get compensation because I have suffered so much of like loss and everything. So in this case, this concept of strict liability was applied, that you need to fulfill 3 conditions. First of all, you are keeping some dangerous thing within your premises. Dangerous thing, water is not dangerous, right? Water we need, but water in a huge quantity becomes dangerous. All right.
Yeah.
Or it is a non-natural use of land. Otherwise, for our daily consumption, we will not store water in such a huge quantity. If you are storing it, it becomes a dangerous thing. So first of all, you are storing some dangerous thing. Secondly, it escaped from
Your
your
voice
premises.
is breaking. Your voice is breaking.
Okay. Is it breaking now also?
Yeah, now it's okay.
Okay. So first is dangerous thing, right? Even some normal thing, if you are storing in a big quantity, it becomes dangerous. Like electricity as such is not dangerous, but where there will be electricity, like main thing will be there. If you go some hospital, malls and all, there will be written, right, danger, do not touch, because it is stored in a huge quantity, right? Same happens for any other things also. Stored in a huge quantity, it becomes dangerous. So first of all, there should be a dangerous thing. Secondly, it escaped. All right, it escaped from your premises and caused loss to the other person. That is the second condition we need to fulfill. And thirdly, prima facie liability. That means court will not see if it was your fault or if it was someone else's fault, but you will be made liable. All right, prima facie liability. That means you will be made liable whether you had your fault or not. All right, is the main case of this thing, strict liability, that these 3 conditions need to be satisfied. All right, and here if these 2 conditions are satisfied, it is prima facie responsibility. Right, you are keeping dangerous thing and it escaped. That means prima facie you are liable. You cannot just escape from it. That is the principle. But it was having certain exceptions. There are 5 exceptions that are applicable, which is which is plaintiff's own fault. That means it was your mistake that it escaped. All right, maybe I am having some wild trees inside my premises and it produces some poisonous fruits or berries. All right, I am having those trees inside my premises. If your horse comes and enters my premises, eats those poisonous berries and dies, I am not responsible. Why? Because it was your fault. You should have taken care of your horse and should have seen that it did not just roam around in your neighbor's premises. So that was the first exception. So I can say that it was his fault only. He failed to take care of his horse. It entered my premises. It did not escape from my premise, basically. So that was an excuse that I can come up with. Secondly, act of God, right? Act of God, we already know that nature played its part. As a result, it happened. I am not responsible. Third is mutual benefit or voluntary non-fit injuria. That means you have given consent. Fine, I had stored water inside my premises, but you also said that whenever needed, you will be using or taking water from there. That means you were also getting benefited out of it. It was mutual benefit of both of us, so you should not complain if it escaped. All right, that was the third condition. Next, fourth is wrongful act of a third party. Some other person did something. All right, maybe I was having wild tree inside my house. I kept the gate closed only. Someone came there and that third person opened my gate. As a result, your horse entered my premises. I'm not liable. Why? Because it was some third party who did something wrong. That was another. And last one was statutory authority. That means some statute or some under some statutory authority it is being done. So even though we were having this concept, right, strict liability, even though it was there, it was hardly of any use because people can come up with any of these excuses. All right, that it was plaintiff's own fault, act of God, mutual benefit, wrongful act of a third person, statutory authority. So in almost all the cases, they would somehow prove any of these and escape the punishment. Okay, so now what happened is that in India also we were following this concept of strict liability, but we saw that there were many cases where people just escaped punishment. They came up with these excuses, and these sort of escape or these kind of situations were rising a lot. All right, so as a result, there was a case, MC Mehta versus Union of India. It was a case of Delhi oleum gas leak case was there. As a result, many people sustained injury. One advocate also died there. And this case was filed before Supreme Court as a public interest litigation by MC Mehta. And in this particular case, court said that strict liability we are having just for the namesake, but it's of no use. So they developed a new concept, which is called as absolute liability.
Liability.
All right, what is absolute liability? It is same like strict liability only, but just minus the exceptions. All right, from strict liability, if you minus the exceptions, it becomes absolute liability. So absolutely liable as in completely liable, right? So accordingly, you can remember. That means you are completely liable, no excuse, nothing. Right? Accordingly, you can remember absolute means without exceptions. Strict means you are strictly liable. There are certain exceptions. 5 exceptions you have. So it was MC Mehta versus Union of India case where oleum gas leak, because of oleum gas leak, many people sustained injury. Supreme Court came up with this principle of absolute liability, which is nothing but strict liability minus the exceptions. Essentials are again dangerous thing you are keeping, and it is like a non-natural use of land, right? You are storing it in a very huge quantity. As a result, someone has sustained injury. Do you want details of this particular case? Because I think you can easily remember it, right? MC Mehta versus Union of India. Details, if you have, you can write that also, right? In exam maybe.
Okay, I'll see. I don't know. I'll have to see our textbook.
Textbook. Okay, fine then. Yeah, so this is basically the thing, all right? You can just simply remember that, okay, fine. There are these two concepts, strict liability and absolute liability. Both comes under no fault liability. Even though you are not having your fault, there is no fault from your side, you will be made liable. MC Mehta versus Union of India, it is also known as oleum gas leak case, where what happened is, there was in Delhi, there was leakage of oleum gas leak from Shriram Food and Fertilizer Industries, and one advocate, because of this accident, one advocate in Tis Hazare Court of Delhi died, and many people sustained injury. As a result, public interest litigation was filed with regard to this. All right. So for this, nothing much to remember. You can simply remember no fault liability. We have two principles, strict liability, absolute liability. What is strict? You are strictly liable. Absolute as in no other way. Two cases you remember, Rylands versus Fletcher. Another one is MC Mehta versus Union of India. Then the ground. If there is dangerous thing that you are keeping and it escapes, prima facie you will be liable. But there are these exceptions, 5 exceptions here. But in case of strict liability, we do not have the exceptions.